Today, the Supreme Court issued a massive 9-0 unanimous ruling, and this one struck down the federal law which bans habitual drug users from owning firearms. If you're a gun owner or if you care about the Second Amendment, this is the landmark ruling that we've been waiting for about a year. The case is US versus Hemani, and the Supreme Court just sent a very definitive, roaring message to the DOJ and the federal government that you cannot automatically strip Americans of their constitutional rights just because they occasionally use cannabis. So let's break down exactly what happened in this ruling, why the government's arguments completely failed and collapsed, and what this means for the future of gun rights in America going forward. Now, before we break down this landmark Second Amendment ruling that just came from the Supreme Court, if you like this type of content and you want to make sure that you get this type of content going forward, make sure you like the video, subscribe, and turn on all notifications to ensure that you get these videos when I release them. Now, as I mentioned, the Supreme Court today issued a 9-0 unanimous decision in another landmark Second Amendment case. This one involves whether the federal government can ban unlawful users of controlled substances from possessing firearms. In this ruling, the Supreme Court unanimously found that the law violates the Second Amendment as applied to the individual in this case. Now, first, let's look at the crazy facts of this case and how this got in the Supreme Court. So here, the individual Ali Hemani, a man from Dallas, Texas, worked a stable job and lived with his parents. Now, back in 2022, federal agents raided his home, essentially under the suspicion of something totally unrelated to the charge here, which turned out to be completely a dead end for the FBI. Hemani was fully cooperative with the law enforcement officers when they raided the home. He handed over the firearm that he kept in the house and even pointed the agents to some marijuana on the property. Now, during an interview with the agents, he honestly admitted to the agents that he smoked marijuana occasionally. I believe he said maybe every other day to help him sleep. Now, there was no evidence of any other crimes whatsoever. He was charged with nothing else. But about 6 months later, the DOJ indicted Hemani under 18 U.S.C. Section 922 G3. That is the federal law making it a crime to possess a firearm if you are an unlawful user of a controlled substance. Under this statute, Hemani was facing up to 15 years in federal prison and a lifetime ban of owning guns. Because of this, he fought back, arguing that the law fundamentally violated the Second Amendment, his two-way rights as applied to him. Now, on review, the Fifth Circuit ultimately agreed with him and found that the federal law here violated the Second Amendment as applied to his situation. In response to that ruling by the Fifth Circuit, which kind of struck down this law, as it was applying to his fact pattern, they decided to file for Supreme Court review. So they filed a cert to the Supreme Court, and the court granted review, and this term heard oral arguments, and now today we have their 9-0 unanimous ruling. Now, in defending this federal law under the Supreme Court's landmark Bruin standard, the government had to prove that this law here aligns with America's historical tradition of firearms regulations. So what did the DOJ do and what did they say? Well, they pointed to some historical laws from the 1700s and the 1800s, targeting what they called habitual drunkards. The government argued that because early America restricted the liberties of severe alcoholics, they could automatically disarm anyone who regularly used cannabis today. However, writing for the Supreme Court and the majority, Justice Gorsuch, completely dismantled this argument. Gorsuch noted that back in the founding era, a habitual drunkard wasn't just someone who drank occasionally or even regularly. It meant someone who drank so much that they were practically incapacitated and mentally incompetent to handle their own affairs. Gorsuch even dropped some hilarious historical truth bombs on the DOJ, pointing out that if regular drinking disqualified you from gun ownership back then in the founding era, well, then the founding fathers themselves would have been completely disarmed. He pointed out that John Adams famously drank hard cider, multiple glasses with his breakfast every single day. James Madison reportedly drank a pint of whiskey every single day. And right before the signing of the Constitution, there were a ton of guests at a farewell party for George Washington, where they famously downed over 100 bottles of wine, plus beer, cider, and punch. The Supreme Court ruled today that you cannot compare an early American who has lost all self-control to a modern citizen who safely uses maybe a mild gummy, essentially to just sleep a few times a week. The government's historical analogy, the Supreme Court found, failed on every single metric. In the opinion of the majority, they stated that this case illustrates a disconnect. The government considers Mr. Hemani an unlawful user of controlled substances because he admits to using marijuana about every other day. But how much marijuana does Mr. Hemani use? In what potency does he use it? And to what effect? Is he routinely unable to manage his affairs, a risk to himself or to his family? Or does he use a mild gummy as a sleep aid a few times a week? We do not know, and the government says it does not matter. The government asks us to analogize him to a habitual drunkard all the same. They also went on to state that we do not question that sometimes an individual's unlawful use of cannabis or other controlled substances may render him a danger to others. But again, the government disclaims the need to show anything like that in this case. Instead, it asks us to conclude that anyone who regularly uses marijuana is categorically violent and dangerous without any further showing, all based on little more than its current say-so, one at odds with its own regulatory actions, and affording the government that kind of broad power to designate an entire group as dangerous and therefore disqualify its members from having a gun would risk allowing it to quickly swallow the Second Amendment altogether. So that is how the majority of the court approached this ruling. Now, you also had some concurrences from Alito, who was joined by Kagan, I believe, then Thomas, and then you also had a concurrence from Justice Jackson, who was joined by Sotomayor. Essentially, when it came to the concurrence of Alito and Kagan, it kind of got even worse for the government because they pointed out the massive kind of glaring hypocrisy of the federal government's current position. Alito noted that marijuana use is incredibly widespread today and that the federal government itself has largely tolerated and fueled a multi-billion-dollar legal marijuana industry across 40 states. He pointed out that just recently the federal government even moved marijuana from Schedule 1 to Schedule 3, and the court essentially told the DOJ that you cannot protect and tolerate a massive commercial market for these types of drugs and cannabis and all of this on the one hand, and then claim that the millions of Americans who use this category are of items is simply just violent and dangerous altogether, and then can be therefore stripped of their 2A rights. Giving the government this broad power to arbitrarily label this entire group as dangerous, according to this concurrence, would again just completely do away with the Second Amendment. Now, when it came to Thomas and his concurrence, he really just spent his entire current concurrence really pointing out some issues surrounding the Commerce Clause and saying that the Second Amendment in this context, the Commerce Clause should have been an issue because the government did not show that this crossed interstate lines, and he has issues with the Commerce Clause at large and really wants to revisit that issue, not just in this case, but other cases as well. Now, when it came to the concurrence written by Justice Jackson, who was joined by Sotomayor, they essentially agreed with the judgment here, the ultimate decision here, but they spent the majority of the concurrence complaining about the Second Amendment, complaining about Bruin and that standard, calling it unworkable, and they believe that they should do away with the Bruin standard and go to something else. Now, before everyone celebrates, we need to look at how narrow this ruling actually is. Justice Gorsuch made it very clear in the ruling that it does not strike down other federal gun bans altogether. Specifically, it does not affect the ban on convicted felons owning firearms, and also it does not stop the laws that ban people from possessing a firearm while they're actively intoxicated or actually high. Also, it does not stop the government from bringing a prosecution if they have individualized, actual facts and proof that a specific person and their drug use makes them dangerous. What it does do is completely kind of block and do away with the automatic blanket disarmament and ban of regular cannabis use in your possession of firearms. It does away with that. It says, that is not just this blanket ban. It does not actually jive with the Second Amendment. It has to be done away with, especially on an as-applied basis. So it's going to open the door to more as-applied challenges. And I would also suspect that it will also impact the 4473's questionnaire on this very issue. However, I do want to state this still is a massive victory for the Second Amendment and a historic reality check for overreaching federal agencies and their laws. The Supreme Court just kind of drew a very hard line in the sand to protect your constitutional rights from bureaucratic overreach in these types of laws. They also outright rejected the government's failed attempt to use historical evidence on habitual drunkards to use that as an analog. The court found that those sources did not meet the government's burden under Bruin. They did not meet that standard, and it did not align with the how and why portions of the Bruin standard. This decision will have implications nationwide, no doubt, and will impact other 2A cases that are going to cite to the logic and rationale and the analysis that was performed by the Supreme Court on this issue. So this is a good case showing how the government must meet its historical burdens under Bruin, and how the government failed here and how courts need to analyze those analogs as they're presented by state governments, local governments, or the federal government in these two-way cases. So what do you think about this case? Do you think the Supreme Court got this ruling right? Let me know down in the comment sections your thoughts and how do you think that this is going to impact other issues going forward. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, subscribe, and turn on all notifications to ensure that you get the fastest updates here. When I release these types of videos, you will get notified of those videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.